This matter is pending at which stage?
No, it will come for motion, Miller.
Motion.
On Wednesday.
So item number 13 that may be taken at 2 p.m.
Okay.
May I please, Your Lordship, I'm paying to adjourn this item number 1 of today's list, Your Lordship.
What is your name?
I'm P. Fukan, appearing on behalf of N. Khera.
Learned Council Ms. P. Kupon on behalf of Learned Council Mr. N. Khera. Have you taken consent from the deed? No.
We have not been informed.
Okay, are you having an objection?
No objection, but we should have to inform.
Lordship, the matter may be listed on Friday.
Not.
Okay, has prayed for adjournment. Learned Government Advocate Mr.
TR Global.
P.R. Gogo is present. Release this.
Okay, Your Lordship.
May I please, Lordship? Lordship, I am pairing for adjournment item number 5, Lordship, on behalf of Mr. S. Samaria. I already informed the other side. S. Samaria, Lordship.
Learned Council Mr.
MM Zaman, Lordship.
Learned Council Mr. S. Sarma.
Samaria, Lordship.
S. Samaria. With the consent of the other side.
Lordship.
Pray for adjournment, list the matter after.
Vacation.
List date given. Date, 7 January.
Lordship.
Can it be on after Bihu Melody? I won't be able to.
Can. On 19 January.
Lordship.
Lordship, I beg to mention item number 3.
Hmm?
Item number 3. 3.
Be-
3. Sir. I'm seeking an adjournment today, Your Lordship. Senior is not available today.
Learned
Yes.
Council Mr.
I'm K. Bhattacharya on behalf of D. Kolita. Yes, sir.
On behalf of Learned.
D. Kolita.
D.
D. Kolita.
D. Kolita has prayed for adjournment. Motion matter, I think
No,
the other side is not present.
no.
This the matter on. 5th January. 5th January.
No, after vacation. Really. Okay, sir.
You want.
No,
or
no,
you
no.
want to later date?
Vacation. Okay.
I get to mention for listing one motion matter Miller, transportation Miller. Motion.
Okay. I can go, motion.
May I please, Your Lordship? So the case is little bit peculiar, Lordship. The judgment expiry decree was passed long back in 2010. And
Why you have so late?
Lordship,
Party decree.
yes, no, Lordship, I'm not extending the expiry decree here. So after passing the expiry decree, Lordship, in 2010 itself, an execution proceeding was done up.
Okay.
So in between this execution, Lordship, this parties has come to a mutual understanding and submitted an application before the executing court that by virtue of my right of relinquishment, I have relinquished this portion of land to those persons. Accordingly, Lordship, I have annexed that petition. Lordship will find starting from the vernacular portion at page 47.
Page 47.
Lordship, this is the vernacular portion, Lordship,
Please
the
read.
original copy, Xerox copy.
Relevant portion, please read the relevant.
Yes. This is a application, Lordship, submitted by the decree holder stating that I have relinquished this portion of land to those persons.
The decree
And
holder.
Decree holder is some Colonel Kasari. Now, Lordship, probably he has expired. He is no more, Lordship, alive. Now, what happened, Lordship? After that, Lordship, she submitted another application before the court that he has given some another land to other person also. Accordingly, they were residing therein. 2022, Lordship, the legal heirs of this Colonel Kasari, probably, Lordship, by instigation of some person, they have filed application again to revive that execution proceeding. Now, Lordship, the execution proceeding is drawn up and this impugn order has been passed to give first possession of the land to the legal heir of judgment degree holder. The problem has created, Lordship, this person has been residing since 1996. They have given me all the Lordship registered sale deed. I have hurriedly filed this application, so I did not annex this document, but all these are genuine documents. So for the time being, I am praying, Lordship, to accommodate 2 weeks time so that I can approach the trial court that this portion of land was relinquished by the person.
You want to stay for 2 weeks.
In Lordship, for 2 weeks, 3 weeks, Lordship, I will satisfy the trial court also regarding this matter.
But you have submitted documents, no?
Yes, Lordship, but I have filed this case highly because this order was.
Yeah, but
Lordship, no, they have said,
That was the document, no?
document, Lordship, this document I can bring on record by additional affidavit, Lordship can
Tomorrow? Yeah,
tomorrow. Yes, but I have to Lordship translate all these documents. These are all vernaculars. That is the problem, Lordship. And language, Lordship.
No, but translation.
Then, yes, if
you
vernacular
have the right
is
translation, not right.
Lordship. By tomorrow, actually, I can bring on record, Lordship.
How many pages?
Around Lordship 40 pages a day.
How many?
Around 40. Lots of sell this, register sell this.
Pages.
Yes, 40. 40.
Translate. Before pages.
40.
The most relevant document you translate. because
All these are Lordship.
I will not be sitting here.
Yes,
So the-
Lordship for the time better, I think Lordship it will be convenient for the court also, Lordship after vacation. For the timing, this proceeding may be stayed, Lordship.
but not documents, no, how can I?
A
say-
document, Lordship, if I am submitting a set of this document, Lordship may keep as a part of this record, Lordship.
No.
Otherwise, I am ready to file additional affidavit, no issue, Lordship, but since case is little bit hurry, Lordship. Lordship, otherwise, if Lordship may fix then part as a tomorrow, I will submit it, Lordship, as additional affidavit.
It will come before me on tomorrow.
Tomorrow, Lordship, yes.
Here for the-
Tomorrow, Lordship, for tomorrow, Lordship, I will bring on.
Tomorrow.
Tomorrow,
You come.
I will submit the additional affidavit today, itself,
Government Council, Mr. J. Kolita
Lordship.
has prayed for time to submit file an additional affidavit.
Affidavit.
Interrogatory application
No, additional affidavit.
to file an additional affidavit. At least in the.
Lordship may kindly may allow me to Lordship only to vernacular person, otherwise registry will not accept my documents, Lordship, without distances copy also.
To submit an IA to bring on record the particular
Of sale, registered sale,
particular registered sale deeds.
Lordship.
Later, but you file.
Yes, Lordship, the provision is a 26 petition, I can file, but Lordship, time is very short, Lordship, that is why I am hurriedly come before you, Lordship. Problem.
But you don't know, you see, the rules are also there. So whether the registry will accept or not, I cannot say. The
That,
rules are also there.
so anyway, if I can file this registry, Lordship can accept this document as is also part of the record. Because I will submit additional affidavit on swearing affidavit also.
May I please, Your Lords. Lordship, here the petitioner is aggrieved with the impugned order passed by the learned principals as Family Code 3, Your Lordship, Kamrup. Your Lordship will find at page 29. That order starts from that page and the relevant para. May I take Your Lordship to page 31? Para 7, 31. Peruse the case records and materials on records perusal so and so reveals that height order dated. Thus said case was dismissed for default of the petitioner considering his absence before this court for 3 consecutive dates. It further reveals that the instant petition was filed by the petitioner on so and so after nearly about 4 months of the dismissal of the suit without condonation of delay petition, Your Lordship. However, the absence of petitions for condonation of delay will not debar the petitioner from claiming restoration of his case under family law if the grounds shown by him for his previous so and so. That was the observation made by the learned court below, and his suit was restored. Lordship, what happened as per procedure? May I take Your Lordship to the Family Court Act? The Family Court, it provides the procedure generally. Section 10. Section 10, Your Lordship. Is 7 in this book. Section 10, procedure generally. Subject to the provisions of this act and the rules, the provisions of the Code of Civil Procedure 1908 and of any other law for the time being in force shall apply to the suit's proceedings other than the proceeding under chapter so and so of the criminal procedure before a family court, and for the purpose of the safe provisions of the code, a family court shall be deemed to be a civil court and shall have all the powers of such court, Your Lordship. That was a suit proceeding, and that husband respondent here, he was required to file one condonation of delay petitions before filing the application under Order 9, Rule 9, Your Lordship, for restoration of the that suit. Lordship, that was not done. And apart from that also, Lordship, in his petition, there is no any whisper regarding any explanation regarding the delay of that, delay of filing that petition. That has not been looked into by the trial court, Your Lordship, and very whimsically, that was restored, and it is the abuse of process of law, Your Lordship. So that is my grievance.
You want to stay?
Yes, my lord.
No. Will issue notice.
Lordship, then it will become infractious. It is fixed on.
Wait one.
No, I'm the wife.
You're the wife.
I'm the wife. I'm the wife, Your Lordship.
What is the petition? Under which section you have the husband?
13(1), Roman 1A and 1B,
Divorce.
filed by the husband, yes.
So this petition, what is the end result of this petition?
Lordship,
What is the end result of the order? What petition was it, which was allowed?
this was the miscellaneous applications for restoration. That application was filed under Order 9, Rule 9, Your Lordship, for restoration of the suit, because suit was dismissed for default for 3 consecutive days, and including 4 days, he remained absent and he was being unrepresented before the court.
Restored.
Yes, that was
taken.
restored, taking into consideration. Yes, my lord.
You want to stay in the divorce procedure?
Yes, my lord. It is apparent,
Will
my,
issue notice.
then my lord, maybe state and your lordship will consider it. For the time being, it may be state, Your Lordship.
We consider.
Because it is apparent on record that it is an abuse of process of law, that procedure has not been adhered to. This is my humble submission, Your Lordship. For the timing, it may be stayed, Your Lordship. Let him come. And I put objection also. Your Lordship will find
This case is pending.
that is for the evidence. Husband has to file evidence.
Immediately after opening of the court.
Yes, Your Lordship. Your Lordship may.
We issue notice immediately after opening of the court. We'll only on returnable they will consider your affair.
Then my lord, then there will be difficulty, my lord. That is why.
Nor your issues have already been formulated.
That is right, madam, or your lordship, but apparently it is there, and with this I have approached before this honorable court. That has to be looked into, your lordship. So for the time being, if that is state, let him come by issuing a notice, and it will be lordship.
Condolation of delay, have you announced the petition this way?
Yeah, I have annexed here.
Yes.
Your lordship will find.
Next.
Yeah, page 25. Oh, sorry. Your lordship will find at page 13, Annexure 2.
Annexure?
Annexure 2, Roman 2. Application under Order 9, Rule 9 of Civil Procedure Code. This is an application under Order 9, Rule 9 of Civil Procedure
Wait.
Code. That is at page 13, 1-3, your lordship.
Yes,
An application under Order 9, Rule 9 of Civil Procedure Code, so and so, and the section 151 of Civil Procedure Code for setting aside the order dated so and so, for dismissal in default of the petitioner due to non-appearance in hearing lifestyle. So application was filed. So without condonation of delay, and surprisingly, in entire petition, there is no any whisper regarding the explanation of delay also. That attempt was also not made. Very in a lackadaisical manner, that petition was filed. There is not even a whisper in his petition also.
that application has to be within 1 month.
Yes, my lord.
That order and rule and application has to be within 1 month.
Yeah, within 1 month, then limitation act. Schedule 122, to restore a suit or appeal or applications. It is 33 in my book. Your lordship may take this also. Itu dilihat. And he has come after 4 months, your lordship. 4 months from that order.
In a family court, the parties are appealing themselves.
Uh,
They are
the
not.
the amicus, because he appointed the amicus curie also. That is why he was unrepresented. That observation was made by the court. And so far as the ground also, that was not also sufficient. Only one list of medicines which can be obtained under the Central Health Medical Scheme as a central government employee, that is simply annexed. That sufficient ground is not also there. But apart from that, it is the abuse of process of law here also. It is quite apparent. And in their petition, I filed an objection also.
See, how can it be appealed to the law? Both of you were trying to settle your dispute. And thereafter, then again, you decided not to settle the dispute, and thereafter you tried to contest the suit.
That court provided.
That is, you have abused the process of law.
No, that is for during account, that conciliation period was there, and apart from that, an attempt was made.
Not that consultation period, after consultation period.
Yes.
Try to settle the dispute.
The respondent husband, actually, he was taking the chance to get it settled, and the petitioner also cooperated, but that failed, you lost.
The program with only 1 day. You see.
Notice will
because
go
it is
and-
proceeding in the family court, not by lawyers. How can a layman know that he has to file a consultation petition? How can he know?
No, he was represented by the lawyer, you lost. That amicus curie was there. So I'm also representing, this petitioner is represented by her lawyer also, counsel, that was allowed.
I do not know who has the good ground for divorce. Whether the husband has a good ground or whether your wife, your.
That
your
is suit is
client-
filed by the husband
I understand.
for taking divorce.
But your client, who is, they weak, I do not know. If it can be brought with some orders or something, if there is something, any reflection, have you filed a divorce petition? Have you filed divorce petition or copy of the divorce petition or objection? So that I can see that you will be prejudiced if no hearing of is passed. Have you filed a copy of the divorce petition? Or written
No, I
objection?
have annexed here the objection which I put in that applications for restoration. That is at page 25. And there, I explain everything, Your Lordship.
Then I'll go to this petition and if you sit down, I'll go through this petition and the objection. If you are insisting on a.
I am not insisting, Your Lordship. I am not insisting.
If I can go through both this and then I will come to a decision. You sit down for a while. Till the time I read it out. It will take some time. It's a long petition, both the petition. and-
I leave it up to Your Lordship. I have submitted. This is what
No,
I have.
but, see, to the petition and the objection, only then I can pass on interim order. Without going through, I can only issue notice.
In their petition, there is even no whisper. Had
Then
there
I
been,
will
had,
sit down for a while. Otherwise, you can read it out to me. You sit down for a while.
so
I'll read it.
no, I honestly, I have perused their petition, but I have not seen any statement regarding that explanation of delay.
Your petition and your objection and the petition, I'll read it and then I'll pass it on. Sit down for a while. I'll have to read it. Please sit down.
Your Lordship may. I leave it up to Your Lordship.
I'm reading it. As you're leaving it up to me, I'm reading it.
No,
Or if you want to stand, then you can continue standing. Let me read it. You know, very devotional, very active.
Is the,
Expert.
no expert, not expert in it. Different, no written statement was filed.
But defense cross-examine the witnesses.
Yes. And there is no interim,
No
there is
interest.
no. Yes.
Current counsel, Mr.
And the Souri,
D.
Souri,
So,
records may be called for.
yes. Current counsel, Mr. D. Chaudhary is present for the petitioner. You can notice to the respondent, is one. For the records of CS number 15, 2024.
Yes.
List of 9. Item 7.
Also.
May I please, Lordship? Lordship, this is the first bill, my lord. This is the first bill, my lord. My lord,
First appeal.
yes, my lord. No, some person judgment and order dated 26/8/2025, my lord. And I mean issue. It is a there is a issue, my lord. And the plaintiff filed a title suit in the Court of Civil Justice Senior Division, Nagaon, my lord. There are many claiming amount, my lord, against the defendants, my lord. But someone having been duly served upon the respondent, my lord, but they did not have any written statement, my lord. So, my lord, for which the suit of proceeding uncourted, but has been dismissed, my lord. Judgment ordered at 26/8/2025, my lord.
Lordship, I don't understand what kind of perspective is here. Lordship, there was a foreigners tribunal in Julia. A case was proceeding against the present investor. He was found not fine. He was Julia. But with the BDP. In the information, that is not under. Lordship, in page number 12. Which were in the title of page number 12. Lordship. 12 page number 12. 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 12 page number
On whether the plaintiff entitled to the degree of recovery of 1.15 crores from the defendant along with the interest of 25% of the income. This is the issue number 1. And the answer of page number 19 also. Could not find any infirmity in this order. Para 24. Can I read?
Yes.
It means that no suit or other legal proceeding can be brought against the government or its officers for any action taken by the government in initiating proceedings of inquiry under the Act in good faith. There is no allegation made by the plaintiff that the action of the government in initiating the proceeding was related in good faith. He has not alleged that some government official had started the inquiry owing to some ulterior motive to impute any malice against the defendant. There is no suggestion that there could be any motive or malice of the plaintiff or any person by defendant. Hence, no proceeding can be brought in the civil court to claim damages against the government even it is bona fide action was initiated by some illegality of kind set up by the plaintiff. In fact, there is no evidence adduced by the plaintiff to prove that the allegation had actually made the proceeding done against him. In any case, even if a mere declaration that the proceeding initiated against the plaintiff in good faith was initiated by some illegality is made by the court, by this court, such a declaration could be useless to the plaintiff, as Section 15 of the Act accords protection to the government and its officers when the act done is in good faith. Herein, there is nothing to suggest that the action initiated against the plaintiff was bereft of the good faith of erroneous or unreasonable. Thus, no ground whatsoever is shown here for allowing the prayer of the plaintiff. The claim made by the plaintiff must fail in the
So he
circumstances
was
of the
declared
case.
not to be a foreigner. Yes.
He was declared not to be a foreigner. What is the wrong lordship
My lord.
in the
Do you
government?
have a case at all?
While a plaintiff may beg to prefer this appeal, my lord.
Government of central government council also there.
No, that is very much clear. Now he is seeking some compensation, but that is also clear that he cannot perform.
Then, my lord, another date may be fixed. I will inform my senior, my lord. Yes, my lord.
After vacation, but
Yes, my lord.
Government Council Minister, you
R.I. Bhuya.
Huh?
R.I. Bhuya. R.I. Bhuya.
RRBA has paid for agreement with the methodology.
Obliged.
Our name may be recorded. I'm for respondent number 1.
I'm 23 TR Gogoi.
Government Council Mr. T. Gogoi, Government Advocate Mr. T. Gogoi.
TR Gogoi.
TR Gogoi, present for the respondent number 23.
23.
And Learned Council, Standing Council. CGC. Learned CGC is being, Council is present for, is a respondent number 1.
Obliged.
Item 8.
Mayor, please, your lordship. Lordship, this is an appeal filed under section 173 of the NC Act, lordship. Against the judgment and award passed by the learned tribunal MSCT Amingao. By judgment dated 10/9/2025 in MSC case number. Yes, admit, and lordship, notice may be issued to that party.
You are the insurer.
No, I'm the claimant.
Bid by the.
Order dated, yes, lordship. Because there was a disability certificate. However, while, yes,
You are not the insurer.
no, I'm not the insurer. J. Das Gupta, lordship.
J.
Das Gupta.
J. W. Present for the claim appeal is agreed by the quantum of compensation. By order dated.
10/9/2025.
Compensation awarded by order dated 10/9.
2025.
10/9. 10/9.
10/9.
10/9/2025. Notices to be issued to the respondents. Returnable on. Call for the transfer of records on MCCS number 247 of 2019.
Much obliged, lordship.
Admit
Wait, please, your lordship.
Yes.
Lord, order the MACT tribunal, my lord. What happened, my lord, in the evidence, my lord? In the entire evidence, it is seen that there is no wrong on the part of the FIGO vehicle. It is the tempo which ran in the wrong side. No, my lord, I am for the owner of a vehicle. That vehicle is not in fault. Your lordship would be pleased to turn to page 18. But learned tribunal, what is done, 50-50. My vehicle had committed no wrong. That tempo ran in the wrong side. Your lordship will just turn in page 18.
How much you corrected?
Well, 50-50%. That your lordship will turn to page 52. Here from the opposite party number 1, United India Insurance Company Limited, and OP number 5, that is the owner of the Ford Figo vehicle, Abed Ali, appellant before your lordship, are directed to pay the award to the claimants within 1 month from the date of order in equal proportion at the ratio 50-50. 16,50,000 is the award. My vehicle is not in fault. That is on evidence. Why that 50-50% will be given?
What is the number of your vehicle?
My lord, number of the vehicle, my lord. Your lordship will turn to page 50. One is tempo is AS 18C 9211 tempo. And another vehicle, my lord, in that paragraph, last line, registration number AS 18C 9211. Another vehicle number. Figo number, my lord. AS 18B. Yes, my lord. My lord, 50% stays to be granted. 50%. I will deposit that 25,000.
No,
I-
no, not 25,000. I
But-
think you have a certain percentage.
My lord, that provision of law is this, either 25,000, either 25,000 or 50% of the awarded amount, whichever is less. So my lord, if it is 50,000, then if it is 8 lakhs, my lord, in that case, I am to deposit 4 lakhs. Yes, my lord, 150, 173,
The old one or the new?
my lord. Yes,
Judgment?
New Act, my lord,
When did for the old one?
my lord, I am reading this old one, my lord, the new one, my lord. 153. 173, my lord. First proviso, my lord, provided that no appeal by any person who required to pay any amount in terms of such award shall be entertained by High Court unless he has deposited with 25,000 rupees or 50% of amount so awarded, whichever is less. Whichever is less means 25,000.
Okay.
Yes, my lord. My lord, only thing is this, my lord. My lord, only thing is this, my lord, I will deposit the amount after vacation, my lord. So, my lord, that may be mentioned,
No,
my lord.
this cannot be mentioned.
My lord,
You deposit, I'll give you a time, within that time you deposit.
my lord. Yes, my lord.
Current council, Mr. MEC is present for the appellant who has filed this appeal, as is agreed by the, judgment and order before.
In the first page itself, my lord.
9/9/2025, passed in.
Yes,
MCC
my
case
lord.
number 271, directing the appellant, owner of the driver, what is his name? Abed Ali.
Owner, Abed Ali.
Abed Ali, to pay 50% as compensation, as he was held liable of contributory negligence. So surveyor submitted that the evidence clearly reflects that the appellant is not responsible of contributory negligence as the driver of the other vehicle number the other vehicle is
Number 8, page 50, my lord. Other vehicle AS 18C.
tempo responsible for rash and negligent act resulting in the accident and death of the claimants. Claimant number 1 subject.
One.
I have issue notice to the respondents returnable on 21st January. Meanwhile, the appellant is directed to pay the statutory amount of rupees 25,000.
Yes, ma'am.
Statutory deposit of rupees 25,000. Where is it?
In the registry, my lord.
Before the registry of this court, within 21st January.
Amar.
A call for the records of MSC case number 567 of 2025.
My lord, in the meantime, my lord, 50% may be staying. 8 lakhs she will get, my lord. But 50% of the awarded amount may be stayed.
So far as, the order directing the appellant to pay the compensation of rupees, or 50% of the compensation within bracket A, rupees 8 lakhs is paid in the next date of listing.
My lord, which is to be payable by the appellant. Which is
I think
payable.
you have record.
Yes, my lord. My lord. 50% payable by the appellant is state, my lord. Oblige, your lordship. Oblige, your lordship.
Item 10.
May I please, Lordship, we are challenging the award and judgment passed by Bogaigaon, MSCT Bogaigaon, my lord. We are challenging only the ground is the dependency, my lord. The loss of no, my lord, actually, this was the government employee, my lord. And according to Assam government notification, my lord, there is no loss of no loss of dependency, my lord. And he is getting full, the family members are getting full family pension, my lord. Which is 100%, my lord, last pay done by them, my lord. So, my lord, it may be admitted, let them come, my lord.
We'll only admit if they won't stay because we see there are.
Okay, my lord.
Informed pension.
Okay,
We'll issue notice and then.
yes, my lord.
In both the cases, no?
Yes, ma'am. No, my lord, in item number 11, my lord, ground is only on quantum, my lord. We are ready to deposit 50%, my lord, in item number 2, 11. 10 of, item, in item number 10, my lord. 10 number. Item ten,
nine to is not going to
not ten.
10
In item ten,
You have for the insurance, no?
yes, my lord, insurance,
The mix,
L Sarma,
someone is present for the applicant, so,
yes, my lord.
notice to the respondents. Number 10, yeah, number 10. This is a matter of 22nd January.
It will be there, no problem. Obliged, my lord.
We admit the appeal,
Okay, my lord.
appeal is admitted. Appeal to litigate, appeal is admitted. Baaki, to litigate.
And record may call for my lord.
Case number?
MSC case number, my lord. 318, my lord.
This
318 of
item
22.
number 10.
Yes, my lord.
380.
318 of 22. 22.
22.
Yes, my lord.
And then 11, item number
11, my lord, on quantum, my lord.
My lord, this is an appeal filed by the insurance company, lordship. It is against the quantum of our.
Insurance company.
Yes, yes.
You will deposit the 50%?
Yes, lordship. It is case regarding I, lordship. A stay may be granted subject to deposit of 50%. The driver.
Appeal to legal runner authority, K. Bhakta, na? Mr. K. Bhakta.
That's right.
Is present for the insurance company. Issue notice to the respondents returnable on 27, call for the transport report of MSC case number
23 of 2023
23 of 2024.
from the member MSC paper.
Then comes from Mr. K. Bhakta.
That's-
Is present for the insurance company. So appellant. Here, the appellant. For insurance company is agreed by the quantum of compensation
But
awarded to the respondent.
yes, lordship. Appeal by the lordship, insurance company, lordship, we will deposit 50% of the ordered amount.
The General Counsel for the insurance company has submitted that the order dated 4/9/2025 of MSC case number 20 of 2022, Levy State. About admissibility. No? I consider the submissions, the order dated. Therefore, the order dated 4/9/2025, 4/9/2025, no?
That's
In MSC case number 23 of 2022 is state, subject to the condition that the insurance company deposits 50% of the compensation amount. Before the
registry of this book.
before the registry of this court.
Within 6 weeks.
Huh?
Within 6 weeks.
Within
6 weeks.
6 weeks from the date of this order. Meanwhile, I dispose now about deposit to about meanwhile, the proceedings of MSC case number 23 of 2022 is stayed until further orders. Issue notice to the respondent, returnable on the 20th. Item number 12 for hearing under rule.
May please, Lord, this second appeal is directed against the judgment and decree passed by the first April court, my lord, thereby reversing the judgment and decree passed by the trial court, my lord. And this, I have already formulated the substance question of law involved in this second appeal, my lord.
Substantial question of law.
My lord.
Okay.
So that is number one, whether the judgment dated 21/7/2025 and decree dated 30/7/2025 passed by the first appellate court entitled Tachikali Pinapur Sansa are purpose being not based on proper appreciation of the evidence on record, my lord. But in the first appeal, appellate court was justified in holding that the title suit number so and so filed by the present appellant as plaintiff was not apparently maintainable in the eye of law. Whether the first appellate court was justified in holding that the suit filed by the appellant was not maintainable in not impeding Sri Indrani Bhagavati as defendant, which is contrary to the order dated 6/9/2024, 14, passed by the trial court in title suit number so and so. Then next. Whether the first appellate could approach the case of the appellant on a wrong standpoint altogether, and consequently the findings and the decision arrived at is vitiated by fundamental misconception of law and facts, my lord. Whether the judgment dated so and so, decree dated so and so, appeal against are contrary to the provisions of the law laid down under section 54 and order 20 rule 18 of the Code of Civil Procedure. But if the findings and the decisions arrived at by the first appellate court leading to the passing of the judgment dated so and so and decree dated so and so, appeal against are vitiated by being based on a conjuncture and surprise, my lord. It on two counts, my lord, the appeal is allowed, my lord, that for non including the parties, my lord, and also the suit is not maintainable because this is the suit for as per this, my lord, order, my lord, court has that for that I will take your lordship to first page 68, my lord, para 37, my lord. May I read, my lord? Page 68, para 37 of the judgment of the appellate court, my lord. From the entire discussion made herein above, it is made out that the learned trial court did not test the legal character of the plaintiff to institute the suit in the purview of the Hindu Marriage Act 1955 and the Hindu Succession Act 1956. This is a suit for partition of landed property, but proper investigation to impede the co-sharers are not made, and as such, the suit suffers the consequences of non-joinder of necessary party. The impugned judgment and decree therefore is based in the law, and it is not maintainable. Admittedly, the plaintiff, before institution of this suit, never filed application under revenue with the revenue authority seeking partition of the suit land. Section 154(1)(d) and subsection 2 of section 154 of the Assam Land and Revenue Regulation 1886 excludes the jurisdiction of the civil court in respect of the claims of persons to perfect partition, and this aspect rests with the revenue authority. This is not a completely contrary to the provisions, my lord. For that, I will draw your lordship attention to section. Section 54, my lord. So 54 of the CPC, petition of partition of state or separation of share, where the decree is for the partition of an undivided estate assessed to the payment of revenue to the government, or for the separate possession of a share of such an estate. The partition of the estate of the separation of the share shall be made by the co-collector or any gazetted or subordinate of the collector deputed by him in this behalf, in accordance with the law, if any, for the time being in force, relating to the partition or the separate possession of shares of such statement. It's a trial court, my lord, by the judgment and decree passed by the trial court, my lord. For that, I will draw your lordship attention. Last part of the page 44, my lord. paragraph 16, in view of the aforesaid discussion and reasons, the suit is decreed with cause. It is held that as the plaintiff has a title over the suit land being the legal heir of late Pradeep Bhagavati, that is 1/2 share of in the land measuring 1 17 lessons of dark number so and so of Nagar Mahal Mauza Shivsagar, and 1/5 share in the land measuring 1 10 lessons of dark number so and so of Nagar Mahal Mauza Shivsagar, and she is entitled to partition of the suit land, and after partition by the competent authority, the plaintiff is also entitled to a separate partition. And accordingly, a petition be issued according for partition as well as mutation of the names of so and so. This was the direction by the trial court, my lord. And this has been set aside by the first appellate court holding that the suit is not maintainable. This is not a suit for perfect partition, my lord. If it is a suit for perfect partition, in that case, no civil suit court has the jurisdiction to try, my lord.
Number 5. Caveat I'm repairing. In this case, I am one of the legal heirs of Kartik Chandra Bhagavati. I have right title interest in the property claimed by the appellant. In the plaintiff's claim? Yes, Your Honor. But the plaintiff knowingly did not make me a party. So I have been included only in the appellate's case on coming to know when I have filed a title suit for my share. In that title suit, the respondent number 1 to 4, they have stated that your Kartik Chandra Bhagavati, Your Honor. He is not the plaintiff. He is not the plaintiff.
No.
He is the father-in-law, claim to be the father-in-law of the plaintiff, Your Honor. But Your Honor, the plaintiff is also not the legally wedded wife of Pradeep Chandra Bhagavati. Because Your Honor, in
That
the
is not,
judgment.
my lord, whether they can raise any objection regarding the admission of the appeal, my lord. The party cannot be allowed to resist, my lord, admission of the appeal. My lord.
Their caveators.
My lord, my lord.
We can submit
My
after their caveators.
But regarding this, that is not allowed, my lord. My lord.
Filed by the appellant, Your Honor. I will not agree with them.
No, my lord.
The title filed by the appellant, this title suit 6 of 2011. Against the impugned judgment, the appeal was filed against the judgment passed in title suit GS6 of 2011. In that case also, they have not made me a party. In the appeal also, the appellant had not made me a party. So on coming to know, I have entered my appearance and I have stated the court that I am a necessary party because it is a collusive between the appellant and the respondent number 1 to 4. Because they are trying to deprive me from my rightful share. Because they have not disclosed my name in both the title suit nor in the appeal. You are father-in-law of the plaintiff? No. I am the sister of the plaintiff. Sister. Your plaintiff sister-in-law. Sister-in-law of the plaintiff. Collusive suit between appellant and respondent number 1 to 4. 1 to 4.
Wonderful.
So they are brothers. Plaintiff and your husband are brothers. Plaintiff's husband and I am the brother and sister. And the appellant is not claiming the share of Pradeep Bhagavati, also the share of her father-in-law, Kartik Chandra Bhagavati. The suit is for partition of all the property of Kartik Chandra Bhagavati and Pradeep Chandra Bhagavati. And in the suit, they have not raised the substantial question of law.
Well, that one, everything can be decided in the appeal, my lord, when the appeal is heard, my lord.
We are very much agreed by the judgment. Which question is this? Indranil Bhagavati. You are for Indranil Bhagavati? No, Your Honor. I am from Monisha Tasdik. Indranil Bhagavati, you have stated just now, Your Honor. He is the son of Pradeep Chandra Bhagavati. And there is a wife of the first wife. And appellant is claiming to be the wife of Pradeep Bhagavati when first wife is there. She cannot be the wife, Your Honor. Because from the first wife, there is no divorce. So she doesn't have the locus standi to claim her right.
So these things, all these things will come when the appeal is heard, Malad, on merit, Malad, on the appeal is heard on merit, Malad, after appearance of the parties, all the parties, my lord. It's after all, this is judgment, this secondary breach against the judgment of reversal, my lord.
Now, if you come to page 62, under the judgment and decree enclosed by them, Your Honor, para 25. You know what is it, no?
So, page, page.
Page 62. 62. Page 62, para 25. Yes. Para 25, title suit matrimonial number 19 of the 2000 was instituted by Srimati Gitanjali Bhagavati against plaintiff's husband on 39/2000, seeking decree of divorce. In his written statement dated 28/5/2001, plaintiff's husband had admitted that both parties of title suit matrimonial 19 of 2000 had solemnized their marriage according Hindu rites on 6/3/1992. He further admitted applicant's pregnancy from him, a childbirth and issue of custody of the child. In her evidence on affidavit also, the petitioner stated that on 17/11/1995, a male child was born out of the wedlock between her and Pradeep Bhagavati. Title suit matrimonial number 19/2000 was not executed on marriage and it was dismissed while order dated 18/11/2023 due to absence of the petitioner. That means there is no divorce, Your Honor, between the first wife and Pradeep Chandra Bhagavati, the husband of the appellant, Your Honor, which is claiming to be the wife, Your Honor. The marriage still subsists, and there is also a child, a boy. So the appellate court has rightly passed, Your Honor, and it was contested on marriage, Your Honor. Both parties have put their arguments in the appellate court. And I finally come to page 64, para 28. Against petition number 82 of 2023 dated 21/2023 filed by the appellant and proforma respondent Srimati Anju Sharma, praying for calling for the case record title suit 19 of 2000. The respondent has not filed any objection. You know, the appellant at that time was the respondent. He have not filed her objection. There is no submission from the learned advocate of the respondent against admission of plaintiff's husband in his written statement dated 28/5/2001 filed in title suit 19 of 2000 that Srimati Gitanjali Bhagavati and he got married as per Hindu rites and they have one son. And this is sufficient to hold that the respondent has admitted the fact, Your Honor. Hence, in this explicit that Srimati Gitanjali Bhagavati as averred in the written statement and petition number 17 of 2014 is wife of late Pradeep Chandra Bhagavati and Indranil Bhagavati is the son of their wedlock. It is admitted. It has been saying, no?
My lord,
Sorry, substantial question of law and communication.
my lord,
Suggest
my lord.
that whether the perception of justifying voting will be true. However, the evidence was not including the way not including say.
Hello.
So we formulate this question.
Madam.
They have admitted that Indranil
No.
Bhagavati is the son, Your Honor. When there is a son, then how can she get the property, Your Honor? So this question will decide.
Madam.
Yes, sir.
Now, for your, my lord, so I draw your lordship attention to a page 41, my lord, para 11 of the judgment decree passed by the trial court, my lord. That point was especially it was discussed, my lord. Decision on issue number 4, page 41, my lord. Issue number 4 relates to whether the suit is bad for non-gender of necessary parties. The defendant has challenged the suit on the ground of non-gender of necessary parties and stated in the WS that the deceased Pradeep Bhagavati
Issue number?
issue number 4, my lord, decision on issue number 4, paragraph 11, my lord, page 41. 41. Time and again, they were requested to furnish the address, my lord, for taking proper steps, my lord, for service of notice, my lord. But they didn't furnish the information, my lord, to the court, my lord. And accordingly, the name was Shastrakov from the plain, my lord. That has been recorded by the trial court, my lord.
No, it is admitted that there is a son. So what are the, where is the, at which page are you, which page have you given the substantial questions of law? Which page?
My lord, that in main appeal I have already framed, my lord, but. Yeah.
Yes, I got it.
Oh,
So,
uh,
on that point, we will admit it, only
uh,
one question,
Page 12, my lord.
page 12. Will not take this evidence question.
My lord. No, this point is actually, my lord, concise. Properly, but,
Only you add
my lord, that's that, my lord.
heard learned senior counsel Mr. NC Das for the appellant. Full stop.
Assisted by Joe.
Assisted by learned counsel Ms.
J. Bushaw.
J. Bushaw.
J. Bushaw.
J. Bush. Full stop. The appellant is agreed by the judgment and order.
Judgment decree, my lord, judgment decree.
For the first instance, in PA number
TR number 21 of 2017.
21 of 2017. Page.
Okay, sir. Learned civil judge, my lord, learned civil judge, senior division, Shivsagar.
Page 51. Passed by learned civil judge, senior division Sitsagar on 21/7/2025.
25.
Number 21 of 2017.
Well.
Allowing the appeal and setting aside the judgment and order dated 31/8/2017. In TX number 6 of 2011. It was declared in favor of the plaintiff by the favor of the plaintiff.
Appellant plaintiff.
Plaintiff took appeal by the municipal number 1. This appeal is admitted on the following substantial question of law. It was very page number 13 F. No? It was to issue notice to the respondents.
Other respondents, other 1 to 4.
Respondent 1 to 4. Caviter is present for respondent number 5.
5.
Caviter to discharge to the all for the records of the title sheet number so and so and title of the number so and so. Please turn the floor. 28 January.
Published below.
Application for withdrawal of the deposited amount, your lordship. I am appearing for the insurance company. The claimants have filed this application IA and I have filed an objection to it, your lordship.
But they are not here.
They are not here, your lord.
You pick some other date there. Learned counsel Miss
A. Biani.
A. Biani.
A. Biani.
A. Biani is present for the insurance company.
Yes, sir.
The claimants are not represented today. Leave this matter on 5th January.
Much obliged.
Item 15.
May I please, lordship. My lord, the matter is already admitted and
by order dated 19/4/2021. And by that order, my lord, one substantial question of law was accepted. And on the last occasion, on 6th of November 2025, it was directed that frames us some more substantial questions of law. And in that situation, I have framed two substantial questions of law, which is already there in my earlier list. Only one that is I was not taken in the earlier occasion. That is may be accepted, and after framing that issue, is substantial question of law, matter may be posted for hearing. Okay.
Where is the order that some more substantial question of law has to be seen?
It is order dated 19/4/2021.
No, this is one substantial question which was framed.
Yes. And on the last occasion, it was after some discussion, it is said that some more may be framed.
It is on 6/11/20.
6/11/25.
We'll admit it there. Already it was there. Third learned counsel, Mr.
K.U. Ahmed.
K.U. Ahmed for the appellant. And learned counsel, Mr.
And Hawk for 1, 2, 3.
And Hawk for respondent number 1, 2, 3. It's stop. While order dated 6/11/2025, it was ordered by this court that this date was fixed. It was observed by this court Narayan. This date was fixed for framing fresh substantial questions of law. Thereby, in addition to the substantial question of law framed on 19/4/2021, this appeal is further substantial question of law as follows are formulated. Number 2. Roman 2, no? Roman 3. Either 1 or 2 will be assessed, Roman 2 or 3 will be assessed. Substantial question of law. So this matter for hearing there?
Yes, ma'am.
You have the LCR and everything?
Yes. Everything is over. It was listed. My lord. Obliged.
My lord, in this case, on last occasion, lordship, as per last order, they were required to file a counter, lordship. This is a transfer petition, civil lordship, for transfer of a divorce case from Principal Judge Family Court to the District Judge Nagaon, lordship.
Yes, sir, actually, I have it.
Copy,
But then copy was also filed to you to here. You haven't received.
sir, no, it not received.
But the copy was served on the yes.
I have no knowledge. He is there with me, lordship, we have no knowledge. Anyway, lordship will fix after the vacation, I will get a copy from them.
After Mr. A. Benjamin is present for the petitioner and learned counsel, Miss S. J. Hayat is present for the sole respondent. Yes, sole statement. For the respondent, and he submitted that they have filed what counter affidavit.
Counter.
They have filed counter affidavit, which of copies to be furnished to the petitioners. This matter on 21st.
Till then, the proceeding, there is a stay order operating, lordship.
Interim part, interim order shall remain in force.
I can send it.
May please your lordship. I am claimant, respondent number 1
I have filed this IA number 276-4 to withdraw the 80% amount from the registry.
You have any objection?
Also, we will be filing an objection to the registry.
They have taken my lord several times. My son, only son was died, my lord. I have suffering.
I don't mind. Let them file an objection. We will give you a convict. Please file an objection. Don't delay. Learned Council meets PB Hazarika, no?
Yes, my lord.
Who is present for the applicant. To appeal and Learned Council Mr. S.P. Sharma is present for the respondent insurance company. He is present for the
Insurance company.
insurance company is the applicant, no?
Yes.
But he is present for the claimant, PB Hazarika is present for the claimant. and-
Respondent number 1.
Huh?
Respondent number 1, Levin.
No, we have two cases, we club it up and part the other. IA and MEC. And Learned Council, Mr. S. Sharma is present for the insurance company. And he submitted that, objection is already, prepared. And he filed objection in IAC 2024.
IA is meant 276-2024.
This matter on 6 January.
But in the main appeal, Lordship, service upon the respondent number 2 is not complete. For number 2 is a vital.
Service on respondent number 2 is submitted. Service reported respondent number 2 is submitted. Item 80.
May please your lordships. My lord, I am for the wife lordships. Appeal is admitted and lordship, there is an IA lordships. 1/4.
Challenges the order dated 7/9/2024 passed by the Honorable Family Court Lordship, where the appellant was directed to meet his only daughter during the court date fixed by the Honorable Family Court Lordship. Lordship, after passing the order, the respondent bring her daughter only once in the family court, and rest she makes some lame excuses. Even on the last occasion, Lordship, she intentionally avoided to bring her daughter in the family court, Lordship. And the Honorable Family Court orally strictly directed the respondent to bring her daughter on the next date, Lordship. Lordship, in this appeal, the appellant only prays before your Lordship to direct the respondent to allow him to meet his daughter twice in a week, maybe on Saturday, on Sunday, outside the court, Lordship. Or,
You have an IA here, file an IA.
yes, please. No.
I was for delay, my lord.
Huh?
I was for delay.
Yes,
Okay,
Lordship.
to this application. you
Yes,
want to meet your
yes,
daughter.
Lordship.
Yes, why not?
Only allow him to meet his daughter outside the court.
There is interim in this one, the main case is still.
Lordship, different number 1 and 2, page 8, Lordship.
Page
And 3, 4 are government, Lordship. Then
8 of the IA or page 8 of the agreement?
I'm reading from appeal memo, Lordship. RSA 160 of 2024.
IA is for?
IA is for impleadment, Lordship. Before that, I want to show the sequence of the parties, Lordship.
Page 8, no?
Yes, Lordship, of the appeal memo.
Okay.
Plaintiff is Halima Khatun and defendant number 1, 2 are Matbar Ali and Nalu Sheikh. 3, 4 are 3 sub-registered Dhubri, 4 some Nur Jamal, 5, 6, 7, 8, your lordship. Muhammad Ali Sheikh, Anwar Hussain, Moniruzzaman Sheikh, Mofidul Sheikh. This IA is for impleadment of these persons, lordship. So lordship, the suit proceeded. The defendant number 1 and 2 filed written statement, annexure 2, page 11. And pro forma defendant also filed written statement, that is annexures 3, page 16. And judgment was passed, lordship, that is page 18. It reflected in page 20. Paragraph 5, the suit proceeded ex parte against defendant number 528 by order dated so and so, and others contested. Now, your lordship, the last portion of the order, page 27. The suit is partly decreed on contest with cost. It is decreed and declared that sale deed number so and so is void
it is decreed and declared that the defendant number 528 did not acquire any right title interest over the suit land by virtue of purchase. So the persons against whom the suit proceeded ex parte lordship, their right title was negated by the trial court. My suit was decreed, but recovery was not granted. Plaintiff lordship, instead of filing appeal against this judgment, filed another suit lordship. That is page 36, annexure 5.
Page
Page 36, lordship. Now, lordship, the defendant number 528 became 1234. And defendant number 12 of that title suit became 5 and 6 in this title suit, lordship.
Page 36,
36, lordship.
defendant number.
1, 2, 3, 4 are the defendant number 528 of that earlier suit. The suit proceeded against them, lordship, the earlier suit.
So you are against the earlier suit of the
Earlier suit, lordship.
1 to 4, na?
1, 2, 4, lordship.
Five,
1, 2,
seven,
3. Lordship, the second suit was contested by these defendants by filing written statement, annexure 6, page 42.
Earlier, they did not.
They did not contested, lordship. The suit was decreed against them. They did not also prefer any title appeal, and the plaintiff also did not prefer any title appeal. Second suit was contested by the defendants, 5 to 8. Now, lordship, the plaintiff, when advised that this suit is not necessary, she can file challenge the earlier suit. Then she filed an title appeal challenging the earlier judgment along with a condonation application. That condonation application was rejected. Against this order, the regular second appeal. And while preparation of the regular second appeal, the earlier defendant number 5 to 8 are not made parties. For that, I have filed this IA for implement of the respondent number 6 to 9, lordship.
Oh, you are the respondent. You are the applicant. in this case.
No, I am the applicant. I am the appellant applicant.
And the defendant is the original.
Defendant 5 to 8. Yes.
Where is the plaintiff?
Plaintiff, I am the plaintiff.
Oh, you are a plaintiff.
Yes, lordship. As my suit was partly decreed, recovery part was not given. So now I have challenged the said judgment.
Give them, I think.
There are some issues, my lord. Lordship had earlier heard it in detail.
Oh, I have heard it.
Yes,
Yes.
lordship. But
That
Why
matter,
did you
my
come
lord,
here?
no, it was a dispose of, they took time, my lord. That matter, my lord, when, my lord, they did not impede us in the RSA. Subsequently, at the time of hearing, they came to know that the defendants were not made party. So by making by filing this IA, they want to impede us. So I raised the issue that limitation has to be condoned. That matter, my lord. I said the limitation has to be condoned, then they can impede us. Because against the earlier, the other defendants, they filed the RSA within the limitation period, 90 days. But against, the lordship may remember.
my lordship may remember yes.
But the
Lordship,
limitation was not. There is
Lordship,
no application for limitation.
there was no caveat by these defendants against the trial court's, title appellate court's order, lordship, against the condonation order. There was no caveat by the respondents. I have made the other defendants as a party respondent here, and thereafter appeal was admitted. As lordship, at the time of admission of appeal, the objection of the respondent was not considered by the
But
court.
they have already admitted. It has already been admitted.
Yes, lordship, my appeal already admitted.
So now we can consider.
So I am praying for consideration, lordship. They are objecting. I have cited one application, one citation, that is, lordship, State of Assam Appellant versus Basanta Burman. Already on last occasion, I have given that judgment, lordship. Paragraph 345.
No, I,
Lordship.
they can impede me, but only after following the due process.
Okay,
Because,
depart by limitation.
yes,
How many days limitation?
no, the regular second appeal was filed within limitation, perhaps against the other defendant. But against us, if they want to impede us now, because 90 days period is already over. So perhaps the limitation period will have to be
Yes,
counted.
yes, come into question.
Lordship,
So my proposal
I
is
am-
that,
Come into play.
my proposal is that let them file an IA. A delay will not be much, my lord. The delay will be controlled and implemented, my lord. Only it's a
Lordship,
few
I
days
have
time.
filed order one, rule 10 application, Lordship. In order one, rule 10, there is no prescribed time limit, Lordship.
Order one rule.
Yes, Lordship. In limitation act, there is no prescribed time limit mentioned for order one, rule 10A. And another judgment of this court, 2010-6 GLR
Order
29.
Then
Will not come because can we be added by way of an amendment? Same thing. Say, for example, we were not made party in the second appeal. So sometime by way of amendment, can the other defendants be made party in this? Obviously no. Similarly, order one rule 10 will also not come because we were party in the earlier appeal or earlier suit. We
yes,
stand,
yes,
we stand in the same footing.
it's so correct.
Lordship, then on,
It's so correct.
then your Lordship may reject my petition. The appeal will proceed against, without impleading them, Lordship.
That's their,
Lordship.
but my proposal will be.
Only, Lordship, my two decisions I am citing, Lordship, that may be recorded, then thereafter your Lordship may take any decision. This is, one is, Lordship, already I have given, State of 1985,
Yeah, already did the earlier suits.
Lordship,
So now this question of order one rule can won't come.
Lordship.
It's so correct.
For that, I am relying on 2010-6 GLR 295. It says, Lordship, 107, there is a power on appellate court to implead any party as respondent during pendency of the regular second appeal. And order 41, rule 20, also there is a procedure. But Lordship, in spite of order 41, rule 20, Lordship, a party can be impleaded under order 1, rule 10A. So I am relying on this judgment. Your Lordship may record my submissions and thereafter your Lordship,
I'll see, I'll now itself.
Lordship.
These, in my humble opinion, these are for strangers, third party, who were not party in the main suit. So they
Lordship,
can be-
paragraph 10 onwards.
I think she has a case maybe why she's insisting on.
No, definitely, my lord, because we were also party. The thing is like this, my lord. Against the main defendant, they executed a sale deed. They sold some land to us. So their sale deed got cancelled. So court held that since the primary sale deed was cancelled, the secondary that sale deed which was executed against us will also get cancelled. So that part is all right. But regarding recovery of possession, that was not ordered in the main suit. So we are still in possession. Though the title part was decided, possession part was not decided. That is the main issue.
Lordship, during pendency of appeal, if any party to be pleaded as respondent, there is a specific provision, order 41, rule 20. May I read, Lordship? Power to adjourn hearing and direct persons.
Order 41,
Rule 20.
but it is second appeal. no?
Yes, Lordship. Order 41, rule 20 will come, Lordship. And order 42 follows order 41, Lordship.
Two,
Lordship.
order 41 rule 20.
Lordship. Power to adjourn hearing.
Yes.
Power to adjourn hearing and direct persons appearing interested to be made respondents, where it appears to the court at the hearing that any person who was a party to the suit in the court from whose decree the appeal is preferred, but who has not been made a party to the appeal, is interested in
Yes,
the
yes,
reason.
It can be, but what
Can
about
be.
the
Limitation.
limitation?
Lordship, order,
Limitation doesn't come in order one rule 10.
Lordship. So
But
this
here-
Somnath citation says, as it is permissible under order 41, rule 20, and as per section 107
paragraph?
provisions.
Which paragraph?
Lordship. 10 onwards, your Lordship will find.
You're reading?
No, Lordship, I could obtain only one book,
Or is
Lordship.
they are reading?
Lordship will also see the subsection sub-rule, ma'am. Rule 2. No respondent shall be added under this rule after the expiry period of limitation for appeal, unless the court for reasons to be recorded allows that to be done. That is there in order 41, rule 20 itself. Sub-rule 2.
Okay.
That part is there, limitation part.
Okay, it's there. But here it is testing on order 1 rule 10.
Somnath judgment is very clear, Lordship. Only difference is that, Lordship, order 1 rule 10 says at the time of suit, Lordship. And 107 of CPC proviso part says, Lordship, appellate court have 107, section 107.
The Somnath judgment you're reading from para 10 to?
Before that, Lordship, I am reading 107 of CPC, Lordship. Powers of appellate court, subject to such conditions and limitations as may be prescribed in an appellate court shall have power to determine a case finally, to remand a case, to frame issues, refer them for trial, to take additional evidence, or to require such evidence to be taken. Subject as aforesaid, the appellate court shall have the same powers and shall perform as nearly as may be the same duties as are conferred and imposed by the court on courts of original jurisdiction in respect of suits instituted therein. So as per order 1 rule 10, any party can be impleaded at any stage, Lordship. That Somnath judgment, Lordship, the plaintiff impleaded some of the legal errors of defendants at the argument stage. That order was under challenge under Article 227. But Somnath judgment held that even if under 227 it can be considered, and the plaintiff, the order,
227 can be considered.
Lordship, and the order,
Now, you are bringing this at the second appellate stage.
Lordship, and it says that, Lordship, para 10 onwards, your Lordship will find that it says in a appellate stage also they can be considered, not only at the argument stage, but even at the appellate stage it can be considered.
Okay, let's see. Let's read.
Para 10, Lordship, to appreciate the submissions of the learned counsel of the petitioner. It would be proper for this court to reproduce the provisions of order 1 rule 10 to CPC, which is accordingly reproduced hereunder. Then 10.2, court may strike out or add parties. The court may at any stage of the proceedings, either upon or without application of either party, and on such terms as may appear to the court to be just, order that the name of any party improperly joined, whether as plaintiff or defendant, may struck out, and that the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary, in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the suit, be added. From bare reading of the aforesaid provision, it appears that the object of the rule is to bring before the court at the same time all the persons who are parties to dispute relating to one subject matter, so that the dispute may be determined at the same time without delay, inconvenience, and expenses of separate action and trials. More so, sub-rule 2 of Rule 10 gives a description to the court to meet every case of defect of parties. A division bench of this court in State of Assam versus Basanta Burman, AIR 1985, that I already relied, Lordship. Paragraph 12 in Hardeva versus Ismail, AIR 1970, Rajasthan 167, a full bench of Rajasthan High Court, while deciding a revision petition, considered the provision of Order 1 and held that Order 1 Rule 9 CPC lays down that no suit shall be defeated by reason of misjoinder or non-joinder of parties, and the court may in every suit deal with the matter in controversy so far as regards the rights and interests of the parties actually before it. The Rajasthan High Court in the aforesaid decision also considered the decision of a full bench of the Allahabad High Court in Benares Bank Limited versus Bhagwan Das, full bench decision, Lordship, wherein the question arose for determining who is necessary party to a proceeding and what should be the test for such determination. The Allahabad High Court in Bhagwan Das noted that there are two tests. There must be a right to some relief against some party in respect of the matter involved in the proceedings in question, and it should not be possible to pass an effective decree in the absence of such a party. The aforesaid decision of the Allahabad High Court was also approved by the Apex Court in the Deputy Commissioner Hardoi in charge Court of Works, Bherawan Estate versus Ramakrishna Narayan. On scrutiny of the provisions of the Order 1 Rule 10-2 CPC as well as law reports as stated supra, this court is of the considered opinion that when the plaintiff failed to implead the necessary parties in the suit either for mistake or for unawareness about the persons who would be the necessary parties, then also the court can ask the parties to implead those persons as a party by way of impleadment. Here, Lordship. No, in the suit they were impleaded. I am trying to implead them in my regular second appeal. They were already parties. During typing, Lordship, they left out. That is the only reason why we did not make them parties, Lordship. So it says that the court even have power, Lordship. Then also the court can ask the parties to implead those persons as a party by way of.
But see, this is not relating to this order. These parties were, this is not similar to your case. These parties were already impleaded earlier.
So this power is always there with the court. The power to implead parties is always there. But for us, after expiry of 90 days, if the judgment appears finality against us. If the appeal is not preferred within 90 days, that judgment, impugn judgment, attains finality against these respondents. So now, if they again want to implead us, they again will have to file the Section 5 petition, delay be condemned, then they can implead us. That procedure will have to be followed.
Then Lordship, on that ground, your Lordship may dismiss, then I will prefer again another application, Lordship.
Yes.
After citing these two judgments, Lordship. Lordship may record my submission. State of Assam versus Basanta Burman.
I don't have the judgment.
On last occasion, I have given, this is para 3-4.
Yes. Oh, ready? Look right here. I have it.
Lordship. Paragraph 345.
This is about a new party only.
Lordship.
Also about new party only.
Lordship, regarding impleadment in appeal and also suit, Lordship, everything was discussed. That limitation part will not come, Lordship.
Yes, it won't come. The
Lordship.
order 1 rule 10, it won't come.
Lordship.
It never comes under order 1 rule 10.
Lordship.
Your application is under section?
Order 1, Rule 10. Read with 151. Even if Lordship, there is any Lordship objection, 151 can be taken into consideration. This is the inherent power of the court, Lordship. And they are already party.
But you see, when we have a specific provision, then 150.
Lordship, for that I have cited an application under Order 1, Rule 10-2. Read with 151.
Function is also for the applicants. To applicants. We have filed this application. Under order 1, rule 10-2, reading section 151 of the Code of Civil Procedure 1908, we will get the CPC for short. bracket close for implement of public parties number 1 to 4 as respondents number 4 to 7 in the connected regular, in the connected RSA 160 of 2022. Administered by S. Das Leonard Council for all the respondents. The respondent
1 to 4, in the IA.
For the respondent number 1 to 4. So I can give a order to. And you have filed an objection also?
Yes.
It is submitted on behalf of the applicants that by that inadvertently on an error, inadvertently, there was an error wherein that respondents number 1 to 4, 1 to 4.
1 to 4.
Have not been included as parties to RSA number 160 of 2024. The parties are necessary parties as the suit was decreed in favor of the party as the suit number. What will be the title suit number?
Lordship, that is
Page number 3.
431, no?
four
PS number
thirty-one,
431 by 2007 was
Seven.
decreed in favor.
partly decreed.
Huh?
Partly decreed.
Partly decreed in the favor, but possession was not,
Recovery of possession part was not
but
given.
no order of recovery of possession was passed relating to the suit land, which was held to be under the ownership and possession of respondent number 1 to 4.
Yes, Lordship.
Who were arrayed as respondent number 5 to 8 in the
Suit, Lordship.
PO2, 5 to 8 in the earlier title suit 431 and 2007. Restored. The petitioner has relied on the decision of Honorable Supreme Court in Supreme Court order, no?
Guwahati High Court Lordships, 1985, 0 AIR, Guwahati,
Of this
13.
court in Somnath Banerjee versus Aropi Rani Security and another reported in 2010 within the 2010 because 6 GLR 295 where it has been held up. There are 10, 11, 12, 13, 14.
Yes,
No.
Lordship. So
There are 14 sleepers.
there are 14 Lordship. Yes, in 14 also the discussions. 14, 15 Lordship,
14
15 Lordship,
and 15.
up to 15 Lordship.
10 of the 15 negative. The petitioner has the petitioners, the applicant has also relied, applicants, applicants, no?
Applicants.
You are appellants.
I am only one person.
Okay, the applicant has also relied on the decision of this court in
The state of Assam versus
Assam
Assam. As on Hassan Ali.
reported in 1985.
Hassan Ali and others.
0 AIR.
All the attorney holders.
It has been held that there are 3, 4 and 5.
Applicants as well.
The learning counsel for the petitioner, applicant has also submitted that as per order 107 of the, as per section 107 of the CPC.
1072, sub-rule 2.
1072 of the CPC. The appellate court shall have the same powers and shall perform as nearly as may be the same duties as are conferred and imposed by the code on courts of original jurisdiction in respect of suits instituted therein. So thereby, the application under section thereby, next paragraph, thereby, the submission of the learned counsel for the respondents that this case, this application is barred by limitation. Holds no water. As this application is under order 1, rule 10-2.
Order 10-2, Lordship. Court
Order
may
1,
strike out
rule
or
10-2 of the
two.
CPC. Please. For contract, the learned counsel for the respondent, Mr. S. Das, has submitted, has also filed an objection and has submitted before this court that the proviso to order 21, order.
Order 41, rule 20.
Order 41, rule 20. Okay, I'll come back and pass an order. We have a meeting also.
Lordship.
My lord is taking up item 20.
Yeah,
20.
I'll continue with the dictation.
My lord.
মমিও লৈ আছিলে ন তাই কৰিলে লাষ্টৰ সেন্টেন্সটো কি আছিলে Rule 20 debars from adding any respondent under this rule after the expiry of period of limitation for appeal, comma, unless the court for reasons to be recorded allows that to be done, comma, on such terms as to cause as it thinks fit. In this case, no prayer has been made to condone the delay of, to condone the period of limitation. To condone the delay, condone the delay in filing the application for impleading respondent number 1 to 4. Full stop. It is further submitted that allowing impleadment at such a later stage would amount to altering the very constitution of the appeal after expiry of the limitation and would seriously prejudice the respondents. It is further submitted that that the respondents have earlier been impleaded in the original title suit. And thus, the decision relied upon by the applicants in Somnath Banerjee's case, Supra, as well as in the case of Basanta Burma, Supra, is not relevant to this case. It is also submitted that as the parties are not new to the suit, comma, this is not a this application under Order 1, Rule 10. Is not maintainable. Next, I have considered the submissions of the bar with circumspection. So it is true that the decision in Basanta Burman's case, Supra, is relating to parties who were not included initially, whereas in this case, the parties were, whereas in this case, the respondents number 1 to 4 were parties to the original title suit. Full stop. এইটো বসন্ত বৰ্মাৰ এইটো দিয়া আছে হা 345 And similarly, the case of Somnath Banerjee is also not relevant to this case. Decision, case of Somnath Banerjee, decision in Somnath Banerjee's case is not relevant to the instant case. Yes, in Somnath Banerjee case, the parties were not implemented initially, whereas in this case, the respondent number 1 to 4 were parties to the suit. Moreover, in this case, no prayer to condone delay has been made to consider the increment of respondent number 1 to 4 even as per order 41 rule 20 of the CPC. It is true that even at the appellate stage, parties may be added, but in this case, but the instant case is not a case of adding new parties, but a case of impleading the parties who were impleading the respondents who were already parties in the original title suit. In fact, court may add parties even without on its own, even without formal application. Under Order 1, Rule 10 of the CPC. Full stop. As the respondents to opposite parties number 1 to 4 were already parties to the original title suit number. As respondent number, title suit number over a method.
431, 2007.
431, 2007.
Seven.
As respondent number 5, 6, 7, and 8, comma. The application under Order 1, Rule 10, read with Section 151 of the CPC hereby stands rejected. In terms of the above observation, this application is rejected.
Lordship, in appeal, other defendants appeared and service complete. LCR also received. Matter was fixed for hearing. Can I pray for a fixed date in the month
Now
of
we'll have to fix dates.
Lordship, January.
What I gather is now we'll have to fix date, but I do not know whether we have to fix dates for appeal or not. I'll again have to go
Already
through
the-
the
already the
judgment
matter
and
was-
order of the. Sorry.
Already the matter was listed in the hearing column earlier, Lordship.
Okay. List this matter, appeal of Liquidia, appeal of parties are represented. LCR is before us, list this matter for hearing on.
Obliged, Lordship.
Highly obliged.
এই জামিন কিটা এই কিতাপখনৰ পৰা ল'ব লাগিব দেই কিতাপখন এইখন হেৰি পিংক মাৰ্কেটত দিয়া আছে এখন
Lordship, before that, in item 21, I am appearing for respondent. Lordship, I have no objection in the IA, the item 21.
21
Yes, Lordship.
just inside
Next item, Lordship.
or next item. Okay, then we will allow
Lordship,
them.
only my record, my
We'll allow the
presence,
item.
my IA.
Yes,
my
yes.
presence. Obliged.
Okay, next item we will allow.
Pending for children, no? After this matter also, your Lordship.
কোনটো কৈ গ'ল তুমি মনত পেলাবা দেই অবজেকশন নাই বুলি কোনটো কৈ গ'ল তুমি মনত পেলাই দিবা কোনটো আইটেম তেওঁ কৈ গ'ল অবজেকশন নাই বুলি Yes.
This is the second appeal, Lordship, against the dismissal of my counterclaim by the trial court and affirmed by the first appellate court, Lordship. We have come up in the several grounds, including non-compliance of Order 41, Rule 31, Lordship. Substantial questions I have mentioned at page 15, Lordship, of my appeal memo, para 10. Whether the first appellate court can decide a first appeal without formulating any point for determination as required under Order 41, Rule 31.
Are you sure? Point for determination was not there?
Not from Lordship.
Page 15.
15 of the appeal memo, Lordship. Not only that, Lordship, without making any discussion on the issues framed on the counterclaim, Lordship,
No
and then
discussion.
without making any decision on some of the issues,
Okay.
may I draw your kind attention, Lordship, to page 30,
Page.
sorry, page 81, Lordship.
Only two questions of law.
Lordship, no, I have framed one non-framing of issues on the point of limitation, Lordship. We have raised the issue, whether findings of the first appellate court are perverse, Lordship, and any other substantial question that party, Lordship.
So one, there was no point for determination.
No.
Are you sure there was no point for determination?
No, my lord.
That is the judgment
issue,
of-
my lord, they need to have, my lord, as per the apex court decision, my lord, at the
They
first
have
appellate,
He has framed issues.
they never raised this question, my lord. In the second appeal, they came.
In second appeal only
Lordship,
they raise issues.
let me come.
That cannot, my lord, I'll got.
So
the
this is the,
And then this, okay, that was, there, it is positive, they have not.
page 54 of the judgment,
Point
Lordship.
for determination was not
May,
taken.
may I point for determination?
No, that's, it's okay, they have agreed, it
Huh.
was not taken up. So
So another point we have raised here in this limitation, we have taken a plea before the WS, in our WS, before the trial court, that suit is barred by limitation and adverse position. No issue has been framed. That part has not been even considered by the first appellate court also, Lordship. So that's why I have come up with a substantial question of law. Once a plea is raised, limitation even not raised, Lordship, limitation is because facts of the case, limitation is a issue, have to be decided under section 3 of limitation by the court itself, Lordship. Whether findings of the first are perverse, Lordship, these are the point out. If Lordship asks me to point out, Lordship, page 81, Lordship,
Page 81.
of my appeal memo, Lordship. Total,
Page 81, yes.
here, Lordship, in page 80, starting from page 80, Lordship, learned trial court has framed 5 issues on the suit and 8 issues, Lordship, at page 82, total 8 issues against the counterclaim.
Okay.
Lordship, at page 93, may I draw your kind attention to Lordship, page 93, Lordship. Issue number 5, the last issue of the suit.
Yes.
In view of the discussions made above, I am of the considered opinion that learned trial court has rightly decided the plaintiffs are entitled to relief as prayed for. Now let me examine the trial court on the issues framed by the counterclaim. Once trial court has decided that yes, plaintiff is entitled, I am of the humble opinion, Lordship, nothing left to decide. But Lordship should have decided this issue number 5 at the end after discussing the issues on the counterclaim, Lordship. That has not been done. If Lordship goes through the decisions on the additional issues number 1, which are on the counterclaim, Lordship. Here, additional issue number 5 and 6, learned trial court has decided both the 2 issues against the counterclaimant appellant. In view of the discussions made above, I am of the considered opinion that there is no requirement of further examination. Can a first appellate court say on that line? First appellate court is the last
He's
court.
agreed, it's okay, he can, because he has discussed other issues.
Nowhere. On what point? On what issues?
Okay.
That is the 41-31, Lordship. Discuss every issue and give the reasons. Nowhere that yes, in view of my findings on issue number 1, 2, 3, 4, whatever it may be. Then issue number, Lordship, 7 and 8, not discussion, nothing else, Lordship. Though there are 8 issues, the last issue on additional counterclaim is additional issue number 1 and 2. I am of the considered opinion there is no dispute that learned trial court has rightly decided.
No, my lord, that
No,
case is not a fit for admission, my lord. Let
For points of
Lordship
determination.
kindly,
You see, point of determination, you must frame.
no,
What is
my
the
lord,
point of
just
determination?
1 minute, my lord.
No.
Firstly, my lord, it is a defective, the original title suit
No,
has
you
not
see,
been annexed.
determination has to be framed.
And
But I
that,
am telling you,
My lord.
when he is deciding on issues, there is a judgment, point of
Yes.
determination is not required.
this is the judgment, my lord.
Point of
Let me read it.
determination alone may not be, Lordship.
Lordship, this is a recent judgment, my lord, regarding that limit, that point, my lord. If they do not take the issue in the first
Don't
appellate,
give my judgment.
para 7, no, Supreme Court.
Then it's okay. Because I have to have.
Issue,
given a judgment.
the High Court framed the issues that has been set aside, para 7, my lord. To the pinpoint, my lord. Para 3, High Court has framed the some that issue order 41 has been issued, that has been set aside by para 7 and para 16 that has been set aside. Para 7 some discussion. They are very recent judgment. That apart, my lord, there is a no annexure of original title suit and no WS of defendant number 7 and 8 who has favored me. That is not annexed. Why it is not annexed, I do not know.
No, no original title suit is there, plate is there.
Judgment, my lord, original judgment, certified copy of the judgment by which I got the decree.
Yes, 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 there is
That
there.
is not
Page 40
annexed.
Page 70 is there. I have annexed. Page 46, copy of the judgment on order date passed by title suit number 3.
It is only in respect of counter claim.
Original
there is-
title, my lord, original. Original, they could not succeed, how come they can come in a counter? That is the original, let him show, my lord. And WS of defendant number 7, why not annexed, my lord? Because he has favored me. He supported my contention.
Filed another appeal, lordship, that is defective. Due to that defective cannot come up, your lordship. I have already cured the defects.
And apart
I
from
can't
that,
say
my
when it
lord,
will come.
execution has been done, my lord, on 12. He has to file fresh case. Already done on 12. Position has been handed over.
Question of position can be restored under 144 if I have no instruction, particularly if even I have done.
Lordship kindly see this is
144
the
is there,
copy
Lord.
from the court, my lord, trial court. Along
Is
with
the
the,
provision of
along
144
with
is
the
there.
CRP, my lord, I went and I have taken the position. And now, my lord, at the most, lordship issued the notice. Admission part, lordship fixed on the next date. I'll come with the mood judgment also.
No, whether a
Because-
caveat, lordship,
Because, my lord, it cannot be, my lord. Because the case is not fit for admission at all. In the light of the judgment which I have given to your lordship, my lord.
Which one?
Just now, my lord, I have given. Naam to kaun hai?
There is only the question taken up for consideration, paragraph 7.
Three, my lord, three, High Court has framed same issue, my lord, identical. The High Court, while deciding the appeal, second appeal, formulated the substantial question of law, whether the incumbent upon appellant to frame the point of determination as per provision of 41 Rule 31 while deciding the first appeal, no, or not. Then, my lord, this appeal, my lord, High Court has set aside. Supreme Court has set aside the order of the High Court. It doesn't remain in
all
the
this will
force.
come up in final hearing, lordship.
Why it will
Because
come?
we
It
are
is not
caveat,
a good
lordship,
case at
they have
all.
the right on the
It
stage.
is not a right case for admission at all, my lord.
No, you see, if issues are framed and points if issues are replied.
No, that is one point.
determination not required to
No,
be taken.
one point limitation whether I have raised the issue or not. When the facts are coming before the court, lordship, that is sale deed was executed in 1960. No,
Limitation, on limitation.
yes, lordship. No position can be taken. There is an admitted fact, lordship. Those will come up. There is
Okay.
there is an.
There you have a question of law. They have a.
Lordship will see, my lord, whether the
Because
this
an
issue has been
appellate
framed
court-
or not, my lord. Lordship will see, my lord, issues have been framed.
On point of limitation.
Yes, yes.
No point of limitation.
Yes,
lordship.
my lord, I am coming, my lord. Let me make my submission, my lord, then my learned friend will be able get ample chance. Yes, one, it matter much. Lordship will see the page 81.
Where?
Page 81 of the memo of appeal.
Where?
15. Against the counterclaim, learned trial court framed the following issues: whether the claim is maintainable in the present, or whether the counterclaim is barred by limitation. It is
That
already
is the
there.
contract claim is barred by limitation, lordship. The suit, I am coming on separate appeal. That is a different matter, lordship.
Let it come, my lord.
Here, my
First appeal, he has to take the plea. He cannot jump over, my lord, one court, leaving one court there, then he came. And there's no, my lord, this point was already raised. It has been discussed, my lord.
here, my submission, humble submission, lordship, 41 not only says point for determination, that is not done. Decision thereon and the reasons of the decision. Lordship, I have pointed out page 94, lordship. My counterclaim has been decided. Not only on surmise, no discussion at all.
Both the
Being
case
a-
come up
being-
together, my lord.
being a-
Otherwise it will be.
Why put the case?
He filed another appeal.
That is against suit, lordship. Some defect has been pointed out that.
That has to become, my lord.
May not be, lordship.
Is the interlink, my lord. I win over in
Decided
title suit.
accordingly.
I win over in his counterclaim. One part he challenged, other part he ran. Moreover, I have done execution also. Let it come, my lord.
Execution is a different part, lordship.
They have
Execution,
twice
44
appeal, man.
CRPC is there, CPC is there.
Earlier,
restoration, if the decree says I am entitled for restoration of my possession. If at all I have not no instruction regarding execution, but lordship, they have filed the execution, that's,
Yeah,
I came to.
they
know
filed
it.
two appeal, my lord. Another appeal is also filed.
No, I am saying, but that is some defect has been pointed out. and-
No, that cannot be, my lord, piecemeal.
You see, this is out of the same title suit.
Same party, same suit, same sheet.
Two appeals, lordship, there.
Out of the same title suit.
Out of
Yeah.
the same title suit, one is title suit against counterclaim. I have filed two appeals before trial court, lordship. One is 1/23, another is 21/24.
Yeah, na.
Both have gone against me, lordship. I have
It-
filed here two appeals. One has been against the suit, some defect has been pointed
You
out.
are the original, you are the,
I am the,
Hmm?
lordship, I am the counterclaimant.
Defendant
Defendant
counterclaim.
counterclaimant.
you are the originally, you are the defendant.
Counterclaimant, lordship.
Yes,
So,
the defendant.
Suit was decreed in
Declared in their
20
favor, my counterclaim was rejected.
rejected. So you
I have
filed two
preferred
appeals.
two appeals before the first appellate court,
First
lordship.
appellate court, yes.
Against,
Both were
both were again dismissed.
against you.
So,
Okay, we'll take those matters together.
Together, my lord, that will
Then-
be convenient, my lord.
because it has to be decided independently, maybe
That
hard
is,
to
my lord, interlinked, my lord.
grounds are different.
Once
lordship.
decided,
Why I'm
Grounds
saying
are
because,
different, lordship.
He's saying that you have not attached the judgment.
trial judgment.
I have given the judgment, lordship. They are saying wrong, sir.
Oh.
Index, lordship, go to the index, lordship.
He's saying.
Original title suit judgment, my lord. My learned friend is misconceiving, my lord. Original title suit judgment which
I
I
have given the
supplied.
lordship here at page 46 to 70, lordship. How they can say that? How they
Because
can say
They
that?
have not gone through the pages maybe.
I have gone, my.
Page 46, lordship, in
Page
my
46.
appeal.
Kindly see this, lord,
Page 46, lordship.
this is judgment of 21/22 and my copy, lordship, kindly see. 2018 judgment, they have not annexed. That is the original judgment.
This is the one judgment passed by the Munsif. Munsif has not passed two different judgments.
দেখাই দিয়েছেন photocopy টা।
Counterclaim. There is a counterclaim. Both and suits and counterclaims have been decided.
No. This judgment is different.
Yes, my lord, may I point out?
This judgment is in their favor and the judgment was dated.
Lordship, page
20
46, lordship.
No. Page 46, yes.
It is different.
This judgment was dated in their favor. It was dated 29 August 2018. And your judgment, same, 36 of 2016. It was
The
dated.
judgment
20
was what we have challenged, lordship, is the 21st November 2022 judgment, lordship.
Lordship, what happened, lordship, there is a judgment was passed. In this judgment, counterclaim issue was not taken into consideration. Then they come for the appeal. And the appeal has remanded back the matter to reconsider their counterclaim only. That was in respect of that, this page 46 judgment was passed only on the
Yes,
counterclaim.
yes.
That was not.
How
been challenged,
the, once a matter has been remanded back, sitting, where is the judgment in existence?
Lordship, let him have a look, my lord, or he can take the photocopy of that.
This
But
is
he
the
was
appellate
right,
court
no?
judgment is just 71, page 71,
He
lordship.
is also right.
Appellate
See,
court
this
judgment is just page 71,
That
lordship.
judgment has not been interfered anywhere. What will happen, my lord, that judgment?
Okay.
My
What they are
land,
We can both the cases.
yes,
together.
yes.
Then we don't have to
Yes, ma'am.
call for judgments or records or anything.
Yes.
So we'll
May,
get.
may I point out just one thing, lordship, page 62, just 1 minute,
Page
lordship.
60.
Page 62.
Page 62, yes.
Or
Yeah.
operative.
In the result, the plaintiff's suit of the plaintiff is decreed. Against we have filed the appeal 1/23. Contest with cause, the counterclaim of the defendant is dismissed. This is the judgment we have challenged in the first appellate court, lordship. And that judgment, appellate court judgment starts at page 72, lordship. 71, lordship.
Hmm.
What judgment they are referring has been remanded back? Non-est judgment, that is, lordship.
It is
How that can I brought on record, lordship?
still in
That is a
force,
non-est judgment.
not has been cancelled. Let him check it, my lord, lordship.
Because it's a counterclaim, which was,
We have
52
challenged
it is there, my lord.
on a separate matter, lordship, because this is, we have come up with the appeal, lordship. Appeal is
That's it.
at page 71.
Para 9, it is there, my lord.
Appellate
Page
court-
52, if your lordship permit me, I'll read out, my lord. It is pertinent to mention here that the instant suit judgment was delivered on 29/8/18 by the learned predecessor declaring the right title interest of the plaintiff over the suit land, after which the appeal was preferred before the Honorable Civil Judge Morigao, wherein the then Honorable Civil Judge Morigao remanded the instant appeal with the suit directing to frame proper issues in respect of the counterclaim. only counterclaim. That title should, that should remain as on date, for which I have done
He's
execution.
saying no, he has filed another appeal
Let
against
it
that.
come, my lord. Let it come together, then my lord, lordship will see.
Because we have not
Lordship
challenged
will
that appeal,
see.
Lordship. We have
Lordship-
challenged the present appeal.
Lordship will
Appeal
see
1 by
whether
23
case is
and-
a fit case for admission or not, my lord. If your lordship, they can satisfy, I have nothing to say. Because I made out my case basing on the document. Let it come together, my
Because
lord.
that judgment has
After
been
tomorrow-
remanded, set
No,
aside.
see, first of all, you have nothing to say here now. Whatever you
The
will say.
caveator,
you
my
will
lord.
say.
Caveator, they have a right to.
I am
stop
the
case, sir.
caveator.
They have a right to.
Not only
stay
say,
on
my
the
lord,
case,
I got to
Lordship.
say,
In
my lord,
relief,
whether
if
case
I
can
want
be
relief,
admitted
in
on.
this case, no interim relief is paid, Lordship.
Apart from that, I have relayed judgment also.
I have a strong case,
Nalage,
Lordship, here
caveator,
for
sir.
admission, Lordship. Substantial questions are
Caveator,
there.
Why do I have to go through this judgment? Why do I have to go through this judgment?
No, judgment because of the case, my lord, they are taking the plea from their memo of appeal. I found whatever, my lord, that's why to overcome that, I have come with the judgment.
Because
That
that
has
judgment
to
is-
be taken at the first appellate, as
It-
per the appeals court decision.
18 judgment is no longer in existence, Lordship.
That cannot interfere.
Because the suit has, Munsif has decreed a suit in 2022 that has been challenged in appeal. And we are here before this court, Lordship, challenging the first appellate court judgment.
Both the case come together, my lord.
Okay, let us bring the cases together.
Yes.
So let's make day after tomorrow, Lordship, filing number, I have got the 15680/25, Lordship.
Learned counsel, Mr.
Yeah,
S. K.
tomorrow
Poddar is present for the appellant and learned counsel, Mr. M. R.
First day, could you?
Borbuia, no?
Yes, my lord, J.I. Borbu.
J.R. Borbuia is
First day, my
present.
lord, instead
No
of
problem.
Wednesday, because we will be the having motions, my lord.
No problem.
Thursday, my lord.
Entire week is a motion week now.
না না এই কারণে কইছো
Entire week is a motion week now.
Yes, yes.
সেদিন আমাক দিও গা
No, no problem, ma'am.
J.R.
Let it be on
Borbuia,
Thursday, no problem, Lord.
learned counsel for the respondents,
না লাগে
list this matter along with,
Filing number 15680/25.
along with what is the
Filing,
number?
filing number, Lordship.
Oh,
156
that was not admitted.
no no
RSA.
I'll
I say I have filed, defect was pointed out, I have cured that, Lordship.
Okay. Filing number to DDA.
may I take back my lord my
15680.
Yes,
that
yes.
judgment can lordship can have a look
156
No, I don't.
15680/25.
purposes also
Or Thursday.
Look at that IA, sir.
lordship
IA 15681.
lordship
And even your execution order also.
yes I'll bring my
15681.
whatever copy is there I'll
That was not there here. These two are different parts.
date কেতিয়া বুধবার কোন নকা কেন
All right, Lordship.
মানে বিচারি থাকলে নামাজ পাইতাম
You know, objection will question, na?
There is an IA 3940. It's a substitution application. The relevant part is at page number. The first paragraph of the application. The appellant number 3 has died. The legal heirs of the appellant need to be substituted.
Okay. Learned counsel, Mr.
F. Faridi.
FID is present for the applicants. Your name is not in the copy?
On behalf of G. Bharadwaj.
Okay, learned counsel, Mr. FID on behalf of learned counsel, Mr. G. Bhardwaj, has, through this application, has represented the applicants of this application through which the applicants have prayed to substitute the legal heirs of the appellant number 3, Topon Kanu, who died on 1/9/2025. Full stop. Learned counsel Miss R. Chaudhary is present for the respondents and has no objection if the legal heirs of Topon Kanu are substituted and implemented in RSA number 95 of 2024.
97.
Oh, 97 of 2024. So accordingly, the application is allowed and the legal heirs of Topon Kanu are to be implemented. The following legal heirs, The following legal heirs of Kapon Kanu are to be included in RSA number 95, no, 97. 97 of 2024.
24.
It will following to yet following to it will be 31, 32, 33, 34, it will page 7 of us, no? Size on us. Nam kita pakai paisa bade. In terms of the above observation, application stands disposed to.
I am for the respondent.
Same.
No, there is no application. There
Oh,
is
no,
I-
it will very to. এতিয়া পাছ কৰিব দৰকাৰ নাই।
Much of much.
You are waiting for a long time.
Yes, madam.
So since the morning you've been waiting.
Yes, madam. I thought it would be taken up very quickly, my lord. Madam, this is an IA, my lord, in this appeal, there are some days of delay, my lord. I have filed this interlocutory application for condonation, notice will go on that.
Learned Counsel Mr. G. Chaudhary is present for the applicant. A notice may be issued to the respondents returnable on date of.
My lord.
Item 24.
Steps within 3 days.
Hmm?
Steps within 3 days,
Okay, steps within 3 days.
my lord.
There's an appeal by the insurance company. There is a delay of 47 days in preparing the appeal. It has come for the first time. Notice may go, madam.
Learned Counsel Mr.
A. Bhattacharya.
A. Bhattacharya is present for the applicant. Notices to be issued to the respondent. Release this matter on 22nd January.
Steps within 3 days.
Okay, steps within 3 days.
Limitation is barred by 170 days, my lord.
Okay.
It is for the
notice-
first time.
Yeah, same order litigation. Learned Counsel Ms. R.
L.
Sharma.
Sharma.
Huh?
L. Sharma.
L. Sharma, okay. Same order, huh?
Oh, bless me.
Item 26.
Please, you mean, Lord?
Yes, yes.
163 days delay, first time notice.
এইটো কাউন্সিলৰ নামটো চেঞ্জ কৰি মিষ্টাৰ এ আৰ আগৰৱাল লিখি দিবা সেম অৰ্ডাৰ হা
That.
27 January. Item 27 of the supplementary cause list.
May I please, Your Lordship, the service upon the sole respondent has been completed.
Okay.
The matter may be fixed for the admission here.
Okay. CRG,
CRG.
you will require the records, no?
Records may be required, Your Lordship, because
Lordship,
BFI.
just I will submit you. Regarding record, I will submit. Then in this case, the matter is regarding injunction to restore the electricity. Order was made absolute. Thereafter, they disconnected. I filed an application 151. Their police report is there that they have disconnected. The ASB report is there that they have not allowed to restore. And also one of the co-landlord, he has appeared. He said that one of my brother has disconnected. And in this matter, they have come to this court against their interlocutory order.
No, Your Lordship, we have not come against that electricity order. We have filed 2 petitions, Your Lordship. The one petition was filed under order 19 rule 2. That petition was filed for the cross-examination of Srimati Rukmani Devi Sharma, who was the original plaintiff and the tenant. What
Okay,
she
we'll call
did.
for the scan copies of the records then. It's not, records will be required.
Lordship, may I submit?
Because he has sublet the suit premises. So we have also annexed the documents in the present CRP.
Lordship, may I
Two petitions were filed and the 2 petitions were rejected on the same day. The other side had not filed any objection.
Okay, we will call for the scan copies of the records.
Lordship, may I submit your Lordship? They filed one petition for cross-examining the plaintiff. That is when the case is fixed for final argument. At that stage, when the evidence is
I'm not granting stay.
no, not granted, but because of this pendency of this case, you may clarify that the trial court is not debarred from proceeding with the restoration matter, because you may kindly see.
No, if I'm not granting stay, it will proceed, They
Your
will-
Lordship, the matter may be proceeded, that is all right.
It will
But
proceed.
these 2 applications are connected with the electricity matter. Because they have disconnected the this Rukmani Devi Sharma, why we want to cross-examine her? Because she has subletted the suit premises to
Your Lordship, there is no issue regarding
and
subletting.
the electricity.
Now we are not getting electricity connection.
She is not in the possession of the
law
premises.
The law of the land is this, Your Lordship, unless I am evicted under the due process of law. I continue to be a tenant and I am entitled to all the essential supply. Here an order of injunction was passed.
We'll call for the records.
You're not calling the court will, you're not, the entire,
No, only scan copies,
Lordship, my electricity is not connected, you know.
No, we have not.
This is his application.
Yes. Your
Lordship,
Lordship,
that-
and I have.
even
Learned
then-
Counsel, Mr.
Lordship,
Yogi,
may,
A Sanchiti, my lord.
A Sanseti is present for the petitioner and learned counsel, Mr. B.K. Jain is present for the respondent. Call for the scan copies of the trial court records.
and
Is the
Lordship,
matter on, no, there's no interim order, 6 January.
your Lordship,
His petition,
Lordship may be fixed on 18th, your Lordship, because
18th.
18th of this month, your Lordship, the record may come scan copy only.
It won't come. 18th of this month it will come.
The 6
6
January,
January.
apart from 6 January, any day, 5th January, yes.
And there is no stay on.